All right, let's try this one more time. See if I can keep her off of it. Commonwealth of Kentucky, Kenton Circuit Family Court, Divisions, yada yada. Insert baby mama name there. Doesn't matter which one it is. This is Kentucky. As you see, this was back in 2021, so it's been a little over 2 years. This matter having been before the court on May 26, 2021, for a hearing compelling respondent to show cause why he should not be held in contempt of court for failure to pay child support, an evidentiary hearing being held, and this court being otherwise sufficiently advised, it is hereby ordered. Oh, I was just going to put this on there and hold it up long enough for y'all to read it, but according to my comments, most of y'all can't read, so I'll do it. No big deal. Okay, respondent was ordered to pay child support in the amount of $374.50 per month, effective August 9th, 2016. A verified application for order showing cause was filed on January 27, 2020, and a show cause order was entered on that same day. A hearing was delayed several times due to COVID-19 pandemic. The Commonwealth entered respondents' child support pay history and arrears calculation into evidence. Commonwealth's exhibit number 1, respondent's arrears is $18,761.59, and the last child support payment was made on November 7, 2018. I didn't dispute that number. I had an attorney. I fucked up. Anyhow, respondent Kenneth T. Scott stipulated to the Commonwealth's proposed pay history and arrears calculation, Commonwealth's exhibit 1. I didn't actually. My attorney did. Anyhow, the court granted funds pursuant to KRS Chapter 31 to respondent for the purposes of obtaining a vocational evaluation. Dr. Kenneth J. Manges was hired and performed a vocational and psychological evaluation on Mr. Scott on January 25, 2021. His report was entered into evidence as Respondent's Exhibit 1. Dr. Manges testified regarding his conclusions of the evaluation. Dr. Manges testified that Respondent completed 8th grade and tried but failed the 9th grade twice. He was last employed as a warehouse worker in 2018. Respondent has not had any specialty training or any certifications. He is residentially challenged and lives in a personal shelter on the Ohio River. Whatever. I'm not going to nitpick it too much. Respondent is not being prescribed any medications and has no predictable medical care. Respondent shattered 2 discs in a work accident in 2018, which causes ongoing pain. Respondent's payment history shows that child support payments are ceased in 2018, meaning I was paying when I could work. Getting epidurals. I was getting 100 microgram patch on my arm of fentanyl, plus Percocet, Neurontin, Flexeril, nerve pills. Anyway, respondent activities of daily living are limited. Respondent has had 1 psychiatric hospitalization in 2017 for depression. Actually, SWAT team showed up in Ludlow. I'm going to take y'all out there one of these days. They tricked me into a 72-hour voluntary thing. You get in there, don't fall for that shit, y'all, because you sign that paper, you don't read it. You agree to the first 72 hours. They decide when to let you go. Anyhow, respondent admitted to smoking marijuana but denied using other illicit drugs or alcohol. That's a fact. Testing performed by Dr. Manges showed an overall intellectual functioning at an average level of intelligence, but has difficulty with his executive functioning and his emotional functioning. Average human, American, I guess. Respondent's Milton Behavioral Diagnostic Assessment was administered to measure his coping skills and deficits regarding his coping with physical pain and medical impairments. The results were that respondent's performance is serious and reflective of enduring psychological difficulties related to pain. I was fine when I could go on a job site, Anyhow, the conclusions of Dr. Manges were that respondent cannot perform work on a consistent and reliable basis. If he were offered a position, he would not be able to follow through on a consistent basis. He would lack the capacity to work without interruption due to pain and psychological difficulties. He would not be able to attend or perform tasks in a timely manner without risking his own safety or safety of others. Dr. Mankey signed a statement of disability, Respondent Exhibit 2, whereby he stated, "It is my opinion that this patient is totally disabled and unable to work. It is my opinion that the patient's disability is permanent." Respondent is need of surgery for shattered disc in his back, but COVID-19 delayed his surgery. Had evidence of that too. They didn't even bother looking at it. Respondent began experiencing residentially challengedness in 2020, and his doctor is hesitant to perform the surgery due to the risk of infection without suitable housing for post-surgical care. Well, that was me and him, actually. Respondent does not receive Social Security or supplemental security income benefits. He applied for Social Security benefits and was denied. He did not appeal that denial due to lack of resources as a result of experiencing residential challenging, whatever, including no address at which to receive mail. Conclusions of law and orders. Contempt is defined as the willful disobedience of or the open disrespect for the court's orders or its rules. Case law. In a civil contempt proceeding. Now, this is the judge's opinion. This is her verdict. This is her. All that case law, all this is her opinion. In a civil contempt proceeding, the initial burden is on the party seeking sanctions to show by clear and convincing evidence that the alleged contemptor has violated a valid court order. Case law. An arrears calculation showing that defendant accumulated arrears in the amount of $18,761.59. And a payment history showing that defendant's last child support payment was on November 7th, 2018. By clear and convincing evidence, defendant has violated the valid child support order of August 9, 2016. I just want y'all to know, I don't know anybody, how many of y'all have dealt with child support, let alone child support in Kentucky. You don't just walk in there and say, "Hey, I'm hurt," and get a doctor. It doesn't work like that. There is so much more evidence. I'm not going to show it here. It's already 7.5 minutes. I done lost half of y'all. All right, anyhow. Once the moving party makes a prima facie case, a presumption of contempt arises, and the burden of the production shifts to the alleged contemptor to show clearly and convincingly that he or she was unable to comply with the court's order or was, for some other reasons, justified in not complying. Case law, another case law. This burden is a heavy one. And is not satisfied by mere assertions of disability. Case law. The alleged contemptor must offer evidence tending to show clearly that he or she made all reasonable efforts to comply. And this is her conclusion. Respondent has shown by clear and convincing, that's me, has shown by clear and convincing evidence that he was unable to comply with this court's order of August 19, 2016. Respondent made all reasonable efforts to comply and therefore shall not be held in contempt. So ordered, 24th day of June, 2021, by the Honorable Beck, Judge Beck. I think this was my first time in front of her. I've been in front of a lot of them, but that was my first time in front of her. Anyhow, here's my disability statement. It is my opinion that this patient is totally disabled and unable to work. It is my opinion that this patient's disability is permanent. 23rd March 2021. There's a signature. That's just his personal info. I'm not giving all that out. The rest of this is public, so it's legit. So I had to have this trial and win with this so that I could then do this to Mars and Associates. Okay, that's just, y'all can look that up if you want. This is all legit. This is who's handling my disability case. So I'm not going to read this. Y'all can if you want. Well, I will read it, actually. Are you disabled and unable to work? yada yada, with your Social Security disability claim, non-attorney representative. Simply saying I'm disabled just isn't enough. To be considered disabled for Social Security purposes, you must be unable to do any substantial work because of your physical or mental condition, and your physical or mental condition must last or be expected to last at least 12 months, 1 year, or be a terminal illness that is expected to result in your death. Isn't that nice? They'll give it to you instantly if you're dying of cancer, and then regret it if you recover. You must have medical evidence, i.e. records and diagnostic tests, to support your claim of disability. Also, unlike some private disability insurance programs, Social Security disability is awarded to people who are completely disabled. There is no partial Social Security disability. Represent clients all across the United States. So it's been pretty good so far. It told me it was going to be a couple years. That's the average. So it's been just over a couple years. Not going to bug him, all obviously. I updated my phone number when I got my new phone. Let me show y'all what they did, though. So I won this. I've already won my case. I mean, clear and convincingly. Beck is no buddy of mine. She went by law. You see all that case law she put on there. And my statement of disability. Let me show y'all what they did. When they served me that warrant from that cunt Coulter, all right, they served me with another civil summons because they tried to get me for a default, but I'm fighting that on my own. Anyway, look at the address they use. Kenton County Justice Center. On the date that I went to court for the, felonious trespassing. Respondent scheduled to appear in case. They did all this just to get me there for this. Because I'm fighting the original one. They tried to get me on a default. I was never served with the original paper. You got 21 days to respond. I'm not one of those people that don't respond. I don't play when it comes to the law, locking me up and all that. I keep up with all that. This is just one little folder of mass folders I have. Anyhow, crooked bastards get me there knowing all this already. They already know this. This is on file. Just to serve me with this, because I'm arguing the default and the original being served. And I recorded all that too, because I always record them, because they're anti-American, rights-violating cunts. And that's just a fact. So, for those of you, I'm sure, the ones in my comments, you're not going to stop just because you see evidence. I don't fit your narrative. I'm not some privileged white boy. I'm a white boy, well, a white man. But, if y'all think this is privilege, I don't know what to tell you, I did it myself, whatever. No, it's baby mamas, actually. The courts and baby mamas. Because everything was cool when I could go to work, not see her cheating, sitting at home. I could show y'all so much evidence on that, but it's irrelevant, actually. I've gotten over it. But they helped put me behind. They helped put me out here. And now they want to charge me criminally for it. This is what they're doing. Now I got a $409 fine also, so when I don't pay that on January 8th, and I will go to court, they're going to lock me up for owing $409 I couldn't pay. Right here, y'all look this up. I'm not going to show you the whole thing, but city attempts to evade Martin. Oh, this is the updated one. I got another one in here. Anyway, it's called Martin versus Boise. Same thing. They're giving out civil citations for no true crimes. And then they, once they cite you so many times, in Boise, I guess, at least, they move it up to a criminal charge. So, what they argued was 8th Amendment violation, cruel and unusual punishment. You're supposed to be able to, I don't know, what's the basic needs for a human, you all? Shelter from the elements, clothe oneself, harvest food, harvest water. Those are the 4 tenets of life right there, natural born rights. Here it is. So y'all can read this, look it up. Sleeping in public, they call it camping. It's all the same though, it's the same thing. Basically, you don't have a right on public property, except for you do. I mean, this is America, y'all. We all own it. I paid mine until I couldn't. Now I can't. That doesn't mean I'm not an American. I don't have my rights still. It's because I don't pay into the system per se, except for I do, because they get paid for taking me to court, for harassing me, for arresting me. That's all them officers have to do. They got nothing better to do. So When I talk my shit to Coulter, he's earned it. Y'all don't see what he does. I'm gonna get out there and show you. It's getting cold now, so I'm gonna hobble up. But I'm gonna show you here if they force me. If not, I'll see y'all in the summer, this spring. If I don't lose all of you before then. Anyhow, I just want to put a little something out there. Maybe y'all can show a little more understanding. We're not all the same. Some of us are out here because we've lost our ability to work. It's not that we wanted to. I went to work actually on a Saturday after working 50 plus hours Monday through Friday because I had 5 kids at home. 4 that were mine, 1 that wasn't. So, we're not all out here for, that's like saying all white people are racist, all black people are murderers or whatever. You know what I mean? Stereotyping. It's the same thing. Anyway, much love, fellow humans. Do better. We all can.